was charged with manslaughter. At the preliminary hearing, the magistrate dismissed the charge on the grounds that the evidence was insufficient. The prosecution then brought the case before a grand jury. After hearing the evidence presented by the prosecution, the grand jury refused to return an indictment. Grand jury refused. The prosecution waited a few months until a new grand jury had been impaneled and brought the case before that grand jury, which returned an indictment charging the defendant with manslaughter. The defendant moves to dismiss the indictment on double jeopardy grounds. Double jeopardy is after being convicted of a crime, so not at the preliminary stage. So A, no, because should the motion be granted? No, because jeopardy had not attached. I like that. No, because there has been no conviction or acquittal. I like that. C, yes, because any proceeding after the preliminary hearing would violate double jeopardy. Well, we're still at the preliminary stage. At that point, he had just gotten charged. So I'm going to strike that. Yes, because bringing the case before a second grand jury was a violation of double jeopardy. That's not a true statement of law. Now, between these two, no, because jeopardy had not attached, and no, because A, no, because jeopardy had not attached, B, no, because there was no conviction or acquittal. I mean, I saw the answer, but I don't know enough law to strike B or A.
Okay, well, that's good. First of all, guys, if when your guy do questions, okay, when you guys do questions, and when you don't understand something like manslaughter, you need to look it up. A manslaughter is a term of art. If you don't know a term of art, the crime, if you don't know the definition of the crimes right away, you have to learn the definition of the crime. Two, terms of art. And in criminal law, one of the things that you want to keep the term of art is the stages. You know, you have the arrest stages, you know, and then you got a trial and you got appeal and a whole bunch of where you line up, where you got a lineup thing, things like that. So level is the stages of the case. So preliminary hearing is one of those stages. Okay, it's a preliminary hearing. It's the beginning hearing. So it's a term of art. You should underline it. A magistrate is not a judge. A magistrate is a judge, but it's not the judge. A magistrate is somebody that kind of like prior thing, not the judge. The judge is the person normally we understand is a judge hear the case. A lot of time we call a magistrate is to tell you that this is before anything. So a magistrate, normally they want to hear probable cause. There's probable cause. A magistrate normally set the bonds. The magistrate normally look at the affidavit to see if there is a probable cause to issue a search warrant. But the duty of a magistrate is very similar to a judge. Okay. Then dismissed the charge on the ground of evidence was insufficient. So evidence was insufficient is good. The prosecution then brought the case before the grand jury. Now you have to know the difference between the grand jury and the normal jury, the jury that convict, right? A grand jury has a job. The job of a grand jury is bill or no bill. That's the job of the grand jury. If there's a bill, then you can go and arrest him. No bill, you gotta let him go. So sometimes you arrest him first because he's doing something wrong out there. Then you go to the grand jury to see if you have, if that guy have probable cause to arrest him. So bill or don't bill. Sometimes you can go to jail and the next day, 2 days, and you get dismissed because the grand jury come with a no bill. A grand jury I forgot. A grand jury is a group of people that come together at one time. And they serve like a month or 2 months. Okay, they don't serve like a jury in a case. Okay. Oh, this is what I remember that I want to tell you, that a grand jury will only appear if you are charged with a felony. You charged with a felony and you have a grand jury. If you charged with a misdemeanor, your case never go in front of a grand jury. And a grand jury, he's in their own room, they own their own thing. And then from time to time, the grand jury can bring you and talk to you. Okay. And the grand jury, normally the grand jury, the bailiff, the judge, and the state. Okay. Those are the people in there. So sometimes the grand jury want to talk to you, then you can be in there. You can go in there and they talk to you, but you cannot bring your attorney inside. Your attorney got to be outside. So you can go in and go out. Okay. Let me ask my lawyer, but your lawyer cannot go inside the grand jury. Now, there's a lot of things about Trump. We try to, there's a whole bunch of cases that the grand jury are looking at Trump. And a whole bunch of cases, the grand jury looking at Trump associates, right? So the Democrat want to see what the grand jury see. Here's another thing. A grand jury can see hearsay. A grand jury can see hearsay. Okay, so the normal jury cannot hear hearsay, but a grand jury can. A grand jury can hear anything. Okay, it can even hear hearsay. A grand jury is confidential. Okay, whatever the grand jury see, it should be confidential. No one can see it, and you cannot use whatever the grand jury have or had to trial your case. The state cannot use it, right? So it's secret. That's the constitutional law. So when Donald Trump was evicted, impeached, they want to see grand jury stuff. So we know the court say, nah, grand jury is a secret. You cannot use it. Okay. So those are some of the things that a grand jury that you need to know. After hearing the evidence presented by the prosecutor, the grand jury refused to return the indictment. See, when you are charged with a felony, you have an indictment. Indictment is go with a felony. Okay, indictment go with the word of felony. Indictment is like a charge, like a piece of paper, a one page. It's the indictment. And that is bill or no bill. So the grand jury return with no bill is the correct way to say it. The grand jury refuse and return a no bill is the proper way to say it. So when no bill is translated into no indictment. When it turns a bill, then the bill will go and transfer that bill to a piece of paper, and it's called the indictment. See, that's the indictment. Okay, and the case with the grand jury. So there's no bill, no indictment. Okay, which returned the indictment change charging with the manslaughter. The defendant moved to dismiss the indictment double jeopardy. Wait a minute. A few months, wait a minute, the prosecutor wait a few months, and then the new grand jury, okay, another grand jury and panel and brought the case before the grand jury. Okay, so they let the new grand jury to hear the case again. Okay, and return the indictment. His bill. Return the indictment is bill. So the defendant moves to dismiss the indictment on the ground of double jeopardy. Well,
okay, Mr. Before you go into the answers, I want to strike one.
Yeah.
I want to strike B.
Why?
B. And circle A, because even if there is a conviction, once there's a conviction, there's no conviction. Like, even if you're convicted, like, you can still appeal, right? And there's still no, at that point, I don't know. I was thinking maybe
you wrong.
Okay, never mind.
Okay, I'm almost there. The defendant moved to dismiss the indictment on double jeopardy grounds. B is wrong because she don't understand what is double jeopardy. Quite understand double jeopardy. So write this down. Mm-hmm. When does double jeopardy attached? This is the test of this question. When is double jeopardy attached? Double jeopardy attached when the jury at trial, when the jury is in its box. When the jury is in its box, then that's when the double G attached. Okay, so what you do is you get the jury in. Okay, you get the jury in, and the jury gonna try your case. So you need 6 for county court. You need 12 for district, and then they bring in about 30, 40, and then you strike, right? Preemption strike, those kind of strike that you're gonna learn, and then you pick 12 of them. Once you pick 12 of them, they're gonna stand up and they sworn. And after they sworn, they're gonna go to their panel, jury panel. They go to the seat. When they go to your seat, if the prosecutor dismissed the case, double jeopardy attached. Double jeopardy attached when the jury sit in its box. Okay, so, and all these are all preliminary stuff. Grand jury is preliminary matters. So the first grand jury, all they does is preliminary. So a grand jury never attach. Anything the grand jury does, deputy never attach, because they are not the jury that hear the case. They are the jury that hear the case, sit on its box, then it's double jeopardy attached. One jeopardy attached, you cannot try the defendant for the same case. That would be double jeopardy attack. Therefore, the answer is, should the motion be granted? No, because jeopardy has not attached. So the defendant tried to dismiss it because he's saying double jeopardy. Well, should the motion granted? No, because jeopardy has not attached. So the thing that you rather remember, jeopardy attached when the jury, the trial jury is in its box. So the answer is A. No, because there has been a no conviction or acquittal. Okay, no conviction, acquittal is not talking about the attached. The grand jury sit on its box. So that's out. Okay. Yes, because proceeding after the preliminary hearing, but it's all wrong. It's all wrong. It's never attached. Okay. So you understand now how that works. So yes.
Can I say that B is wrong because it's not part of the topic under double jeopardy and I won't be tested on conviction or acquittal when they're asking me about double jeopardy?
That is correct, because it has a little bit of double jeopardy in it, not that much. So it does get the carpet wet, but there's not much water spilling it. It's not as much as, so this is kinda, but this is the best. You see it? So it's kind of wrong because conviction, right? Well, we really don't care about conviction. The rule is when the jury sit in its box, not conviction. So it's kind of not quite there, but there is conviction or no, or acquittal. See it? A little bit.
Dr. V.
Yes.
Has there ever, and I'm not sure, but I think I've seen fact patterns where they've tested us on, is there ever a situation where the jury has been sworn, but they haven't been impaneled yet?
It must be impaneled.
So if they're just sworn in, but before they've been impaneled to their seat, let's say he makes a move to do something, or double jeopardy is not attached at this point. If they have not been impaneled, even though they've been sworn.
Right. Impanel is even impanel is one step. Impanel is one step further. This is what happened. Sometimes the judge go, okay, I got good news and bad news. Good news is some people can go home. Bad news, some people got to stay. So number jury 5, 6, 7, 1, stay. Raise your hand. Do you later you are picked? And then you know what the judge did? You can now go home. Come back tomorrow. So we'll come back tomorrow, the jury in the panel. Then that's when the jury attached.
So being in the box means being impaneled?
Say one more time.
Being in the box means being in the panel.
Yeah. The same word, in the jury box or impanel. Yeah.
I like in the box better, but it has to be impaneled in order for jeopardy to attach.
Yeah, there's two words they use, just like the word indictment. No, refuse no indictment. It should be no bill. Okay, should be no bill. Terrible drafting. Okay, not there. There's no the grand jury never say no indictment. The grand jury say no bill.
Okay, we got you.
Okay, so this is kind of like good to get you guys to it. And I picked this question. There's a reason why I picked it. Okay, very good. Anybody else have any other questions?
So once it's impaneled, now your liberty interest is at jeopardy now.
Yes.
So now we've impaneled it. You're at jeopardy. It's double jeopardy if we come back and try to convict me on the same thing.
So you impaneled it, and then the prosecutor say, well, I'm going to dismiss the case. I'm going to dismiss the case. I'm going to charge with you later. It's double jeopardy attached.
I got
Okay.
you. I got you.
Okay, and that's terrible. That is just terrible. You got, trust me, I have so much, I still have it. I can't say I don't worry, but whenever I go to trial, I'm worried because if we not win, the client can go to jail, or the client cannot expunge or non-disclosure the criminal. And a lot of time, I have a case right now. Okay, do you know some people plead guilty even though they're not guilty?
All the
Yes.
time.
You have to know that. And that's weird. That's weird, but it happened all the time. I have right now, in the past, I have many cases that my client tell me they didn't do it, but they have to plead guilty because they cannot take a risk to go to jail or to have a record. Now here's a good example. I have one case right now, my client telling me they did not steal. And it's a theft. And if you have a theft record, you cannot find a job, even a small theft. So the state, which is terrible, would offer you something called pretrial diversion.
Yes.
And pretrial diversion allow you to serve sometimes, but it allows you to expunge your record, right?
Right.
But you have to go through that. A lot of my people, especially young people, like students. I have one case right now, a young girl, 18 years old. And I think that they're gonna pick pretrial diversion because they cannot take a risk. And if they don't, and you are a lawyer, you tell them that, listen, a pretrial diversion is as good as acquittal. Well, the only thing is, you gotta say you have to admit you did it, but then I can expunge it later. It's never existed. It never happened, right? But you in there. But some people go, well, no, I didn't do it. I got to go trial. And that's what very few. And then what happened is you scared to death as a lawyer. You say, oh my God, they're not listening to me. They want to take that risk. So I just want to let you know the way you do it. And I saw this magnificent lawyer did it. And I was so relieved that he did it in front of me for another case, because I'm going to trial too, because when you go to trial, they call first, second, and third, right? First don't go, you go. Second don't go, you go. See what I'm saying? So they don't want to wait the jury. So he goes, John, I would like for you to talk to my client. I suggest my client to take the plea, and my client refused to take the plea. And I think it's a good plea. So I want your honor to talk to my client before I go to trial on record. So that record will save your ass, and it will stay all with the case. You understand? It will stay with all the case of any lawyer. And you know, when they go to jail, they have a lot of time because they become lawyers. When they're in jail, and they sue you for malpractice, or they say your lawyer did it like that, right? So that records will look into it, and you tell the judge that, hey, take the deal. And he refused to, you're done. You now no longer legal malpractice, and you cannot really overturn for for bad lawyering assistant. What is that? What is the word when you counseling? You don't give good counsel.
Ineffective assistance of counsel.
There you go. So I saw he did that, and I go, oh, dang. And you know what I've been doing before I saw that? I write a letter and I make him sign it.
Right.
My name is so-and-so, you know, I inform you, and sign it. And I hate to do that, you know, and the client go, why you made me sign that?
Right.
Right? It's terrible, right?
It is.
So
Yeah.
I now saw a brilliant lawyer who have whole bunch of experience, and that's all he does is criminal law. And, you know, he been around. And, you know, the first thing they do when they go to jail is they're going to sue your ass. Okay. That's one of the reasons they want to overturn that thing. So I saw that from that day on, I go, let's go to trial.
you know, Dr. V. Hello?
Yeah.
Dr. V, I had the opportunity to intern at the DA's office in my hometown. And what I found to be interesting was that, just like you were saying, there was a situation where they had the young man, I forgot